Hi, good afternoon, everyone. Thank you so much for taking out time for this webinar. On behalf of Origin IP Academy, I welcome all of you today. And today we will be talking about new product launch and patent infringement risk. So, when a new product is launched, it's a very exciting time for any organization. But if proper due diligence before product launch is not done, then this excitement can turn into a nightmare. So there are a couple of things to be taken into consideration before a new product is launched. Especially patent infringement risk analysis is mandatory step that has to be followed. The way IP or patents are getting filed in the world, for every product you take, there are chances that there are some existing valid patents that overlap with your new product. Take example of computer mouse. So if you're planning to make this product, there may be some 10 or 15 patents that relate to this particular product. So even if your design is new, there is a possibility that the components inside, they are already patented by any third parties. So segregation of all the parts, nomenclature of all the components of a device, and then performing a patent search, identification of patents that you might be infringing is very important right in the beginning before you even plan to formulate features of a particular product. So this webinar will be focused more on patent infringement risk analysis. Okay, so my name is Bindu Sharma and I represent Origin IP Academy, and I will be taking this webinar today. Flow of the presentation is going to be, before we understand patent infringement, it's very important to understand what are the rights of patent holder, because patent infringement is nothing but it's violation of patent rights of a patent holder or patent owner. We also call it a patentee. So once you understand what rights patent holder has, it's very easy to understand how infringement happens and how we can avoid it. And then I will also try to enlighten you on the small steps that you can prevent or that you can take care of to avoid infringement of patent rights. And we will support this presentation with few case laws, few cases. In fact, I will start my presentation with few cases so that you just have feel of the subject matter. So these things, Apple sued Samsung for patent infringement, then Microsoft sued Apple. So these are these days very common headlines of IP news. So so why this happens, how this happens, what happens after such lawsuits are filed, and how one can avoid the happening of such instances is very important to understand. So once you understand the risk analysis part of it, things become very easy to handle. Okay, so there is a recent case where Apple pays huge amount of money to a company, Vernatex. So compared to Apple, Vernatex is a very small company, but this company is, I feel they have collected a substantial amount of royalties out of patent infringement lawsuits that they have filed against various companies, and Apple happens to be one of most talked about companies they enforce their rights upon. So in this case, Apple happened to infringe 4 patents relating to FaceTime video calling services, and all those 4 patents, they were owned by Vernatex. Apple was sued by Vernatex, and Vernatex registered the patents related to FaceTime video service between 2002 to 2011. Then during the arguments, Apple also argued that it was using different technologies in its FaceTime services. So finally, the court decided the case, and Apple was ordered to pay 368.2 million USD in damages for infringing 4 patents of Vernatex. Now, Vernatex is a very small company, and the kind of damages they received from Apple, they were phenomenal and comparable with their annual revenues. Okay, now we'll take another case where Boston universities use Apple for patent infringement. So the patents of Boston University, the patent in question was assigned to trustees of Boston University in November 1997. So university is saying that iPhone 5, iPad, MacBook Air use a semiconductor for which Boston University had a patent, and they also asked for ban of selling some of Apple products as a slice of as well as slice of company's profits. So this again is another case. This is an Indian case where the two companies, Anand Electronics and Futuristic Concepts Media Limited, they were using digital transmission system technology to manufacture VCD. But these people, they didn't realize, and they didn't do any groundwork before manufacturing these VCDs. And later they got to know that Philips already had a patent on these technologies, and you see the consequences. So in India, Philips had patent protection for this technology. So then Delhi High Court ordered the two Indian companies to stop manufacturing the VCDs that infringed Philips' digital transmission system. So the lesson we learn from this case is using technology protected by others can drive you out of business. So, and I would like to emphasize here is that this usage of others' technology may be intentional or non-intentional, but in both the cases it is infringement and violation of IP rights. So you have to be very, very careful before you manufacture any product, that you do your bit of due diligence before product launch. Then this again is a very interesting story where in 1980s, Texas Instruments found that Japanese companies such as Hitachi, Mitsubishi, OK, Fujitsu, Toshiba, Sharp, and Samsung, they are infringing 10 patents on dynamic random access memory chip. Texas, they filed complaint in the year 1986. So almost all the companies, they took license for use of Texas patents. So in this case, you see that Japanese companies, they took license. So this means that even though they were infringing, but later on when they realized or they got some notices from Texas Instruments, they took license, they took permission from Texas Instruments for using the patents. So in the period 1986 to the first half of 1993, Texas Instruments earned 1.5 billion in royalty payments from these licenses, and in this case there were a couple of out-of-court settlements also for which there is no data available. So now you see the kind of damages the companies have been collecting. So enforcement of patent rights is also considered to be a good source of revenue. So if you look at the numbers, IP litigations have been very expensive in the past. So history tells that IP litigations are one of the most expensive litigations, and the kind of damages the companies have collected, you can just see the numbers and count the zeros. So these are some of the top damages that have been awarded in the history for patent infringement cases. We always talk about protection of intellectual property. You should file patents, you should have copyrights, but we ignore one of the very important components, that is, you should protect your IP. At the same time, it's more important to respect IP that belongs to third parties. I always believe that if you fail to protect your own IP, consequences are under control. But if you infringe any third party's IP, the consequences are not under your control. So anything can happen if this part of due diligence is not done by you, because then you put everything on stake: money, time, reputation of the company. So play safe and do your bit of due diligence right in the beginning. So initial due diligence before product launch can be immensely useful for your business to avoid undesirable surprises in the future. And more important is that having this analysis done, you have lots of mental peace. So even if there is a risk, you find that, okay, 2 patents you are likely to infringe, even if there is a risk and you are ready to take that kind of risk, at least you are aware of the extent of risk and you are aware of the consequences, and you can be better prepared if you know the extent of risk in advance. So before we proceed further, let's understand what exactly is a patent. So patents are usually filed for the products or the processes. So when we say product, it may be a tangible product like a cell phone. A cell phone, in fact, is a very broad term. So maybe a visual display, or the touch screen. Touch screen can be a component. There can be patents on the processes, like process to make a drug. So patent is mainly for the product or process where such product or process is novel, non-obvious, and has industrial application. And patent is a statutory right. When we say statutory right, it is the right granted by the government on an invention for a specific period of time. So specific period of time has been, you see this term being used from time to time. So specific period of time. Then we also say that subject to terms and conditions. So which means that generally speaking, term of a patent is 20 years, provided you reply all office sections and you prosecute your applications well, and you pay all the renewals well, and renewals in time, and then assuming that there is no opposition in the process. So in case there is opposition, then you are successfully able to contest it. So you can see this picture. This is a certificate of grant. So this is how Indian Patent Office issues the certificate, and you have title, application number, name and address of applicant. So in the patent specification, for those who are not from IP industry, so in the patent specification, you have to describe everything about your product or process. And at the end of the write-up, there is a section called as claims. So you describe everything, but at the end of the document, you say that I have described everything, but I claim only this portion of the document. Okay, so claims actually is one of the most critical parts of a patent specifications, and claim determines scope and kind of rights that are granted to you by the government. So if there is a process to manufacture a drug, aspirin, in the industry, I would describe maybe 10 steps in the specification, but out of 10 steps, there is a possibility that 8 steps are already known in the industry. So it's only 2 steps that are unique to my patent. Okay, so in that case, I describe everything in patent specification, but I claim rights only on those 2 claims which pertain to the steps that are unique to my invention. So this means that when I file specification like this and patent is granted, I get rights only on those 2 steps that I have covered in the claims. So claim determine scope and kind of rights that are extended to you by means of a patent grant. And very important to understand, especially in this kind of investigation, patent rights are territorial. This means that if you are granted an Indian patent, it is valid only in India. And if you have a US patent, it is applicable only in the US. So now if I'll give you one example. Okay, so here is the example. So now you see Indian map. So if you have only if you have Indian patent, so that is valid only in the territory of India. So that means people in Africa, Europe, Asia, South America, they can use it without your permission. So I'll repeat this. If you have Indian patent, it is valid only in India, and people outside India can use it without your permission. Similarly, if there is a European patent that is not granted in the territory of India, you are safe to use that patent in the territory of India. And I would request you not to take these statements without any further legal assistance, because these are generic statements that I'm making, but you should always seek legal assistance before using such patents. So what I wish to convey here is that patent rights are territorial. So Indian patent is valid only in India, US patent is valid only in US. And if you have Indian patent, you can prevent others. So patent gives you negative rights, it does not give you positive rights. So it gives you negative right that you can prevent others. So if you have an Indian patent, the right that patent law gives you is you can prevent others from making, using, of selling, offering for sale, and even importing. So importing is very important component, because if you have Indian patent and any US company wants to export that product to India, you can block importing of such product. Okay, so I'll just summarize this. So patent rights are territorial. Indian patent is valid only in India. So if you have Indian patent, you have negative rights that you can prevent others from making, using, selling, offering for sale, and even importing that product in the territory of India. Now, in Indian patent law, there is no specific definition given for infringement of patent rights. But from the right of patent holder, you can interpret definition of infringement. So infringement is nothing but violation of these rights of patent holder. So if you make any product for which there is Indian patent, that means you are violating somebody else's IP rights. So violation of rights of patentee is patent infringement. Infringement of patent rights takes place when you are unauthorized user of third party's IP. So this in fact holds good for copyright also. So with respect to patent, so infringement of patent rights is when somebody's patent or IP rights are used in any unauthorized way, and the person who is using that IP or patent has not taken any consent, license, or assignment from the patent holder, and patent rights are territorial. So I hope infringement of patent rights is clear. Now, clearance search or freedom to operate search is essential. So this search that ensures that you are not infringing any patent rights is called as clearance study or freedom to operate search. So I'll give you one example here. So if you see this product cell phone, and there is display system here, okay? So it is a touch screen. So if you are inventor of touch screen, this does not give you right to manufacture the product itself, because there may be n number of other components in the device for which third parties may have valid patents in the territory of India or whatever country you are looking at. So in order to make this kind of product, you have to open this machine. You have to find out what all components this machine has. Then you have to take help from a hardware engineer to find out nomenclature of all those components. Then you have to perform patent search for each and every component, and then you have to see how many valid patents are there. Then you have to check legal status of those patents and find out how many of them they are valid. Some of them they would have abandoned, or some of them they would have expired. So, and then you have to see if manufacturing of this product and all components inside is violating claims of any patent or not. So this kind of study is called as clearance study, or it is called as freedom to operate search. So typically, the kind of steps that are taken for performing clearance search, I'm sure in the audience, people who are from IP industry, they would be knowing about this. So clearance search is done for product or process to prepare product or both. Then all the components have to be defined. For a product, all components have to be defined. Then for each component, you have to pull the patents and applications in a given country. And when you identify patents or applications, maybe you can take a timeline of nearly 22 years to be on safer side. As you know, that life of a patent is 20 years. And for FTO or clearance kind of search, you should take into consideration only the valid patents. You don't need to worry about the expired or abandoned patents, but only the valid patents. So that's why 20 years is the timeline that you should be looking at. But to be on safer side, you can just take a timeline of 22 years and make sure that you have not missed anything. And apart from the country for which you are doing this clearance search, it's very important to perform one round of search in WIPO patent scope, because you should always know the international applications that are in process, because those applications will have one more chance to enter the country for which you are doing patent search. So you never know, there may be a risk that those after you finish your FTO, you have more applications adding up in India, and those applications may come may be filed in India through conventional route or PCT route. So you should never miss international applications at the time of performing a FTO search. And also, you will see in this presentation, sometimes the word patent has been used and sometimes the word patent application is used. So when we say patent, it is a granted patent. And when it is a patent application, that means the application is admitted but patent is not yet granted. So patent applications you can view only after they are published. So every patent office maintains its own database. So if you are doing a product launch in US, so you should do US specific search, so for which you can check US PTO database plus patent scope, as I told you, is a must to be checked, because you should not miss the PCT application that will enter in US within 30 years from the date of priority. So after you identify the patents that may be encroaching, that you might be encroaching by launching your product, then you can do claim mapping. So claim mapping is a process wherein you highlight portions of the claims that might be overlapping with your product. So claim mapping gives you clear-cut idea on what is the extent of overlap and how many claims you will be infringing, whether they are independent claims or they are dependent claims. So claim mapping gives you clear-cut picture on extent of infringement, and concluding your findings by looking at claim mapping is it becomes very easy. And also, opinion on infringement risk should always be given as per national laws. There may be, even though most of the countries today are TRIPS compliant, but still there may be a possibility of small here and there, small variation with respect to definition of infringement. And case laws may be different from one country to other country. So opinion on infringement risk should always be as per national laws, and it's a good idea to include some good case laws at the time of giving opinion on infringement risk. So what are the challenges, what are the difficulties one find during at the time of performing this kind of search? So as I told you, that FTO search should be performed only on the patents that are valid. So how do we find out whether the patent is valid or not? It is found by checking legal status of that patent in the official website of a particular country. So suppose you have to check legal status of patents in the territory of India, then you will go to Indian Patent Office website, search that particular patent by its number or whatsoever, and then you check legal status of the patent to find out whether it's expired or still alive. Then FTO search should be jurisdiction specific, so it has to be country specific. So if you are launching product only in India, there is no point doing FTO for US or China. So restrict your search only to India. And also you should check the chances of a patent application being filed in desired jurisdiction. So track PCT international applications always. And then you should be able to differentiate between abandoned, lapsed, and expired patents. This is extremely important step. As you know that after a patent is granted, one has to pay renewal fee every year. So if you fail to pay renewal fee in time, the patent gets lapsed. So it becomes invalid for a particular period of time. So if you're doing patent search, you find such patent that has been lapsed because of non-payment of renewal fee, I request you that you mark that patent in red, because you should keep checking such patents periodically. After 6 months, again check, because after patent is lapsed, there is one chance for the patent holder to restore that patent by paying some extra fees. So lapsed patent should always be on red alert, because if you have considered this patent to be non-valid and later it is restored by a patent office, then you will be in trouble. So lapsed patents should be marked red, and they should be monitored periodically. And expired patents are the ones that are void, null and void, and there is no chance of restoration. So expired patents can be taken as expired patents, so there is no chance of restoration. Then is the term abandoned patent. So abandoned is the term that is used with respect to patent applications, not the granted patent. So patent applications, they can get abandoned for various reasons. If you have not filed complete specification within 12 months from date of filing of your provisional application, your application gets abandoned and there is no way you can restore it. 12 months period is gone. That means you have no chance to file the same application. And then there is a period, there is a specific time given for paying examination fees. So if you fail to pay examination fees within 48 months from the date of priority or date of filing, whichever is earlier, even then your patent application gets abandoned and there is no way you can restore it. So this is the difference between abandoned, lapsed, and expired patents. Then you should know correctly how to calculate term of a patent. So if it is Indian patent, it may be 20 years from the date of filing. So if it is Indian patent that has entered India through PCT route, then 20 years calculation will start from the date of international filing. So you should know, section 53 talks about calculation of term of patent. So you should know precisely how to calculate this term, because this is very helpful for you to find out whether it is expired patent or not. And you can also calculate expected time of expiry. So there may be possibility that patent is important for you, but it is very close to what you are going to manufacture. In that case, if term of patent is you can calculate term of the patent and see if there is you have one more chance. Other than patents, you should also look for other forms of IP. There may be violation of trademark also, whether you have right permissions to use particular trademark. So there may be a trademark which is new trademark in India, but that may be in use in US or China. So you have to take care of other forms of IP also. And FTO, I feel FTO should be repeated at least 1 or 2 times after every 6 months. There may be addition of applications or granted patents which you have missed in the first round, because unlike other forms of IP, FTO is a very sensitive search and you cannot take any kind of risk when it is FTO search. So you should monitor applications periodically. Why we are saying here applications is that if there is any any patent application, and you feel that it is very relevant for you, and it might get rejected later on, or sometimes the patent holder will not be interested in prosecuting that application, so it may abandon later on. So applications for which patent is yet to be granted, they should be monitored periodically to see whether they are granted or not. There is any serious problem, there may be opposition related to that application. So all these things, they play a very vital role in FTO search. So now, assuming that you are a passionate innovator, and you found 2 or 3 patents that are very close to your product, but and then you know the extent of risk that you are taking, then what could be the bypass option? So there are a couple of ways you can try it out. All of them, they may not be feasible in a given circumstance, but still, take license if feasible. This option works in very few cases, because your most of the times the patent that you will be infringing will be with your competitors. So taking license from them, taking permission from them to use it for your product may not be a very feasible option. There could be another way that you can always assess strength of the patent which you're likely to infringe. So if you're infringing 2 patents, but those 2 patents are not very strong patents, they can be opposed very easily, and they are not really very strong to sustain a litigation, maybe some risk you can take. So if the patents that you are likely to infringe are not very strong patents, and you still want to manufacture the product without caring about infringement, then you can take some risk by assessing strength of the patent, and strength of the patent can be assessed by validation or invalidation search. You can always calculate expiry date of patent. So if it is expiring very soon, maybe you can wait. And this is very interesting way to bypass option. You should study assignee's track record. See, sometimes what happens that there are some companies, they hold good patents, but they don't have a track record that they have been filing lawsuits. So this you might find probably strange, but I feel there are companies filing good patents, so but they don't have any track record that they have ever filed litigation. So this also can be one of the things you should be considering at the time of taking risk with respect to usage of patents. And sometimes you may, with or without reason, you may want to take some risk. Okay, we'll see. We'll use it and we'll see. So, but at least by doing FTO search, you will know the risk. You will know the risk and you will be better prepared to handle that risk in the long run. Okay, I'll take this one case. This is probably one of the most painful cases so far, and I always feel sad when I talk about this case study, but this is very important. I cannot ignore this. So Polaroid versus Eastman Kodak. In this case, Kodak infringed 7 instant camera and films patents that were owned by Polaroid. But in this case, interesting thing is that Kodak did thorough due diligence right in the beginning, and they hired a good team of attorneys, and they took various opinions on infringement. So 7 years before producing its first commercial instant photography product, Kodak retained a patent law firm to conduct patent clearance studies. But in spite of this, they happen to infringe the patents of Polaroid. So attorneys considered over 250 Polaroid and non-Polaroid patents in the technology and rendered over 67 written and many other oral opinions on the patents. So after this much effort also, Kodak infringed patents of Polaroid. The court found that Kodak consulted its attorneys early and often as it developed its instant photography system. So consequences of this case law was that Kodak was forced to shut down its 1.5 billion USD manufacturing plant. It had to lay off 700 workers and spend nearly 500 million US dollars buying back the 16 million cameras it sold between 1976 to 1985. So in this case, you see that court can also ask one to buy back the products that infringe the third party's IP rights. 673 million US dollars damages were paid to Polaroid at the end of prolonged 14 years litigation process, which finally ended in 1990. And I tell you, sustaining 14 years long litigation in US itself is it's a disaster actually. So Kodak was out of instant picture business for nearly 15 years. So Kodak's infringement of any one or more of the patents in suit was not willful and deliberate. So total award was phenomenal that was awarded to Polaroid. So this is one of the famous patent infringement cases, and the lesson you learn from this case study is that if you're planning a new product development effort and you have discovered a patent or patents that you might infringe, it's good business practice to obtain opinion of experts. This opinion should be obtained before undertaking or continuing any activity that might be considered as infringement. And more important is lack of well-seasoned opinion of counsel can result in a willful infringement and increased damages if you are sued for patent infringement and wind up on the losing end. So conclusion is, I'll conclude this talk now. So conclusion is that new product launch is a very exciting time for any organization, but it's a good idea to take to get clearance search done to understand patent infringement risk. Consequences of patent infringement may be fatal for your organization, and precaution is always better than cure, and clearance search moreover gives you lots of mental peace. I'll just briefly explain you about Origin IP Academy. So Origin IP Academy is dedicated completely for IP learning. So we conduct corporate trainings and we have 3 or 4 different levels for corporate trainings, and our trainings are completely customized to match your requirements, duration, number of people, topics. So everything is designed specifically for you to fit into your requirement. And for people who are working in IP departments or who want to pursue their career in IPR, we have lots of certificate courses in technology evaluation, patentability search, FTO analysis, validation, and invalidation search, certificate course in patent landscape analysis, patent specification drafting. And this is our highest selling course, Indian Patent Agent Examination. So we provide study material for this course, and you can whosoever wants to prepare for patent agent examination, they can buy our material and start their preparation. And I'm glad to share that our study material for this exam is also available in European Patent Office Library. So with this, I thank all of you. Any questions, any feedback, you can always let us know.